Hello, good afternoon, everybody, and welcome to another live episode of Tuesdays with Mitch. Every Tuesdays, we sit down with the expert himself, Mitchell Proner, a personal injury attorney with over 30 years of experience. I'm your host and fellow paralegal here at Proner and Proner, Emmeline. So today we have a very interesting topic. We have 5 tricks insurance companies use to pay less for an accident. Now, Mitchell, a lot of these times, these insurance companies, they are businesses. Why shouldn't an injured person trust insurance companies after an incident?
Okay, so I'm doing this over 30 years, and I can tell you, insurance companies are not your good neighbor. They're they try to pay as little as possible in claims, and people get bombarded with billboards and news about frivolous claims, but you never hear about frivolous defenses. And that's typically what is encountered on. I don't take frivolous cases. I don't have the time. I take legitimate claims and present them for payment on behalf of my clients. And insurance companies, they have the usual tactics that they engage in to try and minimize the amount of money that they pay on legitimate claims. The first thing they do is oftentimes before the victim even gets a lawyer, they'll try and settle it with a lowball offer. They're not going to pay somebody without an attorney what the case is worth. There's been numerous studies that show that people, and you just Google it, whether somebody gets more with an attorney or not. People get a lot more money with an attorney than they do without. And that's because the insurance companies, they come in with low ball offers. They do not give fair compensation for pain and suffering, and they certainly don't pay substantial money. There's no such thing as getting $1 million settlements without an attorney. It just doesn't exist. The second thing that they do is they try to get recorded statements. And anytime they're trying to get a recorded statement, they're trying to minimize their exposure, to pay as little money as possible. They are trained to get admissions against interest because in a case, there are rules of evidence. Somebody might have heard watching TV or the movies the term hearsay. Objection, hearsay. What hearsay is simply he said this or she said this. The legal concept is an out-of-court statement sought to be introduced in court to prove the truth of the matter asserted. But basically, there are exceptions to hearsay, and you can think of the open mouth insert foot rule. An admission against interest is always admissible as an exception to hearsay, which means if an insurance company can get someone to say something to minimize their claim, that's admissible. So they take statements and they record them. You might try and report your claim to the insurance carrier, and you'll get a recording that says, for quality control, our phones are recorded to ensure quality control, or we're recording the call. Basically, there are one state or one party and two party states when it comes to recording. In some states, both parties to a conversation need to know that the conversation is being recorded. In other states, only one party has to know. But by giving that advisory term, you're on knowledge that your call is being recorded. Now it can be used against you. And they could say to you, how are you? And you answer fine, even though you're in pain. And the next day you're in tremendous pain and you're going to a doctor, maybe you're getting a surgery. And now they're using that recorded statement to say, oh, this individual is fine, and who knows what happened to him after the accident, that they needed a surgery. It had nothing to do with the accident. I'm giving a simple example, but that's the purpose of those recorded statements. The third thing that they could do is insurance companies, they delay the process. Typically, we show up every time in court and we say, we're ready to go. Anytime there's a deposition, we say, we're ready to go. We have a trial date, we say, we're ready to go. The other side, they say, we need more time. We're not ready. Oh, we're going to get you that information you need. Delay, delay, delay. Because while they're delaying the claim, the insurance carrier holds on to their money and they're drawing interest on their money. So it makes them more money while it's in their pocket. So if they set aside a certain amount of money to pay a claim, if they could hold on to that money for 3 years, they draw interest on it and they can make more money. And that's a tactic. They don't try to settle cases quickly for what they're worth. They delay. The fourth thing that they do is they try to deny that the treatment is related or that you made a good recovery or that the conditions you're suffering from are not from the accident. So they have doctors on hand on every case. And those doctors, if they have a doctor that's always giving them favorable reports and other doctors that sometimes give them favorable reports and sometimes say, no, this person really is injured, which one do you think they want as their expert? They want the expert that's always giving them what they need. And what is it an insurance carrier needs? Well, first of all, that the victim is exaggerating their conditions. They're not as bad as they say. The second thing is that they're malingering, that they could get better. Maybe they are better, but they're pretending they're not for financial gain. The third thing is they really are disabled, but it has nothing to do with the accident. It has to do with aging or other illness-related injuries that have nothing to do with injury. So that's the fourth thing that they do. And the fifth thing they do is they blame the victim for the accident. No matter how it occurs, they try and assert that my clients are at fault for the incident. And that's typically the last of the tools in their toolbox. And those are the 5 tricks that insurance carriers use to minimize payments.
So if anyone out there feels like they have a legitimate claim, they've suffered a personal injury accident, feel free to always contact us. It's always confidential, 1-800-321-1234. Follow us on all of our socials, Facebook, Instagram. We're easily found as Proner and Proner. Subscribe to us on YouTube. Subscribe to us and follow us anywhere you can because you never want to miss an informative video with Mitchell. And hopefully get you to understand personal injury. If you have a case, hopefully you don't have one in the future, you don't sustain an accident. You made a great point, Mitchell, about how some insurance carriers try to delay settlements or the case for their own business gains. How do you typically handle insurance carriers that are known for delaying fair settlement offers or even lowballing settlement offers?
Well, there's 2 things. First thing is we're aggressive. What we do is we don't, you might see ads saying a firm is the largest firm in the world. I give all the cases my personal attention. I've got a team of attorneys and paralegals that work for me, but at the same rate, we keep strict controls in our computer system to make sure that the cases are moving. Every case has a checklist that has to be maintained. And no cases are left with some kid right out of law school. Nobody's watching them. The second thing is, first thing we do is we try and settle the case. If we can't settle it, we're prepared to litigate. And we show up prepared and we're ready to go. And that's what we do to keep the pressure on, to keep the case moving, is we have strict computer controls. We don't sit on them, and we're available. We're ready to try the case. And that keeps the pressure on the insurance carrier. And the fact that everybody knows that we have a reputation for being available and ready to try the case gives them reason to try and settle with us.
Okay, great. Let's see. I believe we have a question coming in from a live member. Okay, so Estefania asked, can an insurance company send an investigator to follow me? What do you think, Mitchell?
Yes. Not a week goes by that I don't get some sort of email with an attachment. It used to be videotapes where a cassette would come in the mail, but now it's attachments to emails to the firm where they've got a surveillance video of one of our clients. And typically they have our client walking in a parking lot, going to the supermarket, taking their kid to school. Sometimes I've had videotapes of my clients working. I've had videotapes of my clients power washing, chopping wood. I had a videotape one time of a client. Literally, it was a kid who got hit by a bus, and he had a bad fracture of his tibial plateau, which is at the knee. And a year and a half later, it had him in a baseball field, and he was literally trying to do a flip in the air, where he would run and jump into a tuck and then land on his feet and fall backwards on his butt, and then get up again and try it again. And he was just in the outfield trying, and they got a videotape of this. But most times it's just walking around the neighborhood, waiting for a bus. And it might not seem like the person is engaged in vigorous activity, but just seeing somebody walking around the neighborhood, standing, waiting for a bus, might give the impression to a jury that maybe this guy could work, that he's not just sitting around in pain. And if they can pay an investigator a couple of $1,000s to follow somebody around for a few days and avoid paying millions of dollars, you can rest assured it's a good investment for them to send that investigator out. So they can and do send the video taking investigators out. When you are in public, they can't go into your house. But when you're in public, you don't have a reasonable expectation of privacy, and you can be filmed, and it can be used against you in a court of law.
That was a great answer, Mitchell. And I will also want to thank Estefania for asking the question. Remember, when we're on live, you can always bring in your questions and Mitchell will bring the answers. We also have another question here coming in from Luis Carlos Perez. Thank you, Luis, for asking us a question and tuning in to our video. Mitchell, what's the dirtiest insurance company strategy you've seen in your 30-year career?
Well, just recently, they had a drone following around one of my clients. That's a new one. I never saw a drone before. I think that's a pretty dirty trick. I think the craziest thing I saw was I had a client, and he was crossing the street, and a car came for him, and to avoid getting hit by the car, he ran out of the way. And the fact that they videotaped that and sent it to us, it just seemed like it was too much of a coincidence that they happened to catch him at that one moment when a car was coming for him at an intersection on the day that he had a physical examination for the insurance company's doctors, and leaving that physical examination for the insurance company's doctors is when he almost gets hit by a car and he runs out of the way. And I thought they must have set that up. And the idea that they would take this poor guy and make him think he was getting hit by a car, that seemed like a pretty dirty trick. So I guess the surveillance is probably the dirtiest stuff, and that one seems to be the dirtiest of the dirty. Other than that, it's just typical dirty tricks using these old tired doctors that come in and say my clients are fine when I know they're not.
And we have to prove all of your medical records, all of your visits to any doctor is shown as the proof for the attorney to help fight your case. So remember, guys, consultations are always free, 1-800-321-1234. Now, I have another question for you, Mitchell. How can an accident victim avoid those tricks and get more compensation? Is there something that the client could do directly, or is this just up to the attorney to fight for them? Or is there anything that they could do to make it easier on their case?
Okay. First thing is get an attorney as soon as possible. Once you have an attorney, the insurance carriers can no longer contact you directly. They cannot contact you without the attorney consenting. And you could be prepared by the attorney before you give any statement. So that's the first thing, is to be protected by counsel. You can't imagine the CEO of an important company in a lawsuit giving a statement without being first prepared by their attorney, and you have the same right. So and for personal injury cases, for my office, you don't pay us up front. We only pay if we win. We only get paid if we win, if we get you money. So it's our agreement is a third at the end of the case. If we don't win the case, you don't owe us anything. Unfortunately, we have a record of being more than successful in 99% of the cases we take. That being said, get an attorney as soon as possible, and don't give any statements without an attorney. Secondly, if you're in pain, document it by going to the doctor. Medical records are evidence. By law, they are proof of injuries in a case. If you say, I'm in pain, and your lawyer says they're in pain, it's not the same thing as if a doctor comes in and says, they came to my office, I examined them, this is what I saw. And right in the medical records, they say complaints of pain. That's proof for your case, and that can get you more money in your claim if you have that proof. Additionally, the doctor might make you feel better, which is more important than any money you get from a case. Third, you should get an attorney that you can talk to, that is available for you, that is not just somebody you see on TV, but you can actually have a conversation with. Fourth, you should have an attorney that if you ask them what's going on with your case, they're prepared to give you an answer. And if you'd like, go into their office and they can show you where your case is. And lastly, get the attorney as soon as possible. So any evidence that might be there that proves you're not at fault for the incident can be obtained.
That's something very admirable about you, Mitchell. I see all the times when clients come into your office, you're straight up with them. You offer to show them their case, exactly what's being worked on. And a lot of the times, they've never gotten this treatment before from a prior attorney, if they had one before coming to us, or even if they've had a case previously. So I think that's a great point to add on and highlight, is that you could always come to us with any questions, concerns, and you'll know exactly what's going on in your case. All the times I hear clients call our office, maybe they have another case with a different attorney, they're concerned because no one speaks to them. Your main priority should be finding an attorney, one that has many years of experience like Mitchell, and also is willing to fight for you and show you exactly what's going on with your case. So Mitchell, do you have any last words for our viewers today?
Yeah, last thing is, not only do we do that as our practice, but that's actually an ethical obligation of every attorney, is to keep in contact with the client, no matter what type of case you have, contract dispute, commercial litigation. Every attorney on the planet has an obligation to keep their client informed of what's going on with their claim. And we try and maintain that ethical obligation with every one of our clients and give them the zealous representation they deserve. And that is our ethical obligation to provide for each and every one of our clients. So thank you, Emmeline, for doing this with me again. And Emmeline is my lovely and talented paralegal, and she's part of our team, and I'm lucky to have her. And I hope the program was informative. Thank you.
Absolutely. Here every Tuesday, guys. Don't forget to tune in, follow us on all of our socials, and just follow and subscribe so you never miss another episodes with Tuesdays with Mitch. Bye, guys.
Thanks. Bye-bye.
My name is Demetrios Veselakis. So I was at a stoplight and somebody rear-ended me. I didn't feel anything, but then after a certain amount of time, I started feeling pain in my lower back. I knew somebody who knew somebody, so then that's how we got connected to Proner and Proner. My first impressions about Proner and Proner were very good. I looked, the reviews online, and a lot of people were pleased with the service, so I decided to go with Proner and Proner. The process, dealing with accidents is always, very stressful, but they were always with me, every point of the way. They made it easier for me, I feel very pleased with the results, and I would recommend the attorneys to friends and families and relatives too.